Welcome to the Aesthetics Licensure Compact Legislative Summit. We appreciate your time and your interest in learning more about the Compact. This project was only possible because of a cooperative agreement with the Department of Defense, and we appreciate their support. My name is Keith Buckout, and I'm a policy analyst here at the Council of State Governments. Along with a team of industry stakeholders, CSG has been engaged in developing the Aesthetics Licensure Compact for a little over a year now, and we're excited to share important information about it with you today. Before we get into the specifics of the Aesthetics Licensure Compact, we'd like to share a little bit about who we are at the Council of State Governments. CSG is a national membership organization for elected and appointed state officials. As you can see, CSG was founded in 1933 at the University of Chicago, and since then we've moved our national headquarters to Lexington, Kentucky. We're the only organization serving all three branches of state government, and we support our members through providing policy research, technical assistance, and analysis, and also by convening our members together to learn from one another. In 2004, CSG launched a policy program aimed at helping states collaborate and develop solutions for multi-state problems called the National Center for Interstate Compacts. NCIC, as we call it, is a research-based and member-driven technical assistance center which facilitates the consideration, creation, and revision of interstate compacts as solutions to multi-state problems. NCIC has facilitated the development or consulted on the development of all of the active 50 state compacts and every single one of the occupational licensure compacts that exist, and we'll tell you more about that during this presentation. I mentioned at the start that the Aesthetics Licensure Compact was developed as part of a cooperative agreement with the Department of Defense. I'm going to lead you to ask, why does DoD care about occupational licensure and compacts? And the answer is because the burden of holding multiple state licenses if you work in a licensed profession is especially burdensome for military spouses because on average, military families are relocated and required to move every 2 to 3 years. And that leads to military spouses and military families experiencing unemployment at a statistically higher rate than the general population. Military spouses also are often carrying 4 to 5 licenses at the same time, and then tracking the licensure requirements and the continuing education requirements and renewal requirements is burdensome, if not unworkable, and can often be very expensive. Interstate licensure compacts provide regulatory certainty for military families, and it also helps professions and economies because many are facing employment shortages, and states' economies benefit from having military spouses in the workforce where they are also providing for their families financially. All of the existing licensure compacts contain provisions developed in collaboration with the Department of Defense that allow military spouses the ability to continue to work regardless of the state where they are relocated. We are grateful to our partners at the Department of Defense for securing funding to create licensure compacts that not only benefit military spouses, but all of the licensees in a chosen profession. Before we get into what is in the Aesthetics Licensure Compact, it's probably best to start at the beginning and explain what is an interstate compact. Interstate compacts are constitutionally authorized, legislatively enacted, and legally binding contracts between 2 or more states. There's contracts between 2 states, among regions of states, and national compacts that are either enacted in every state or nearly every state. Historically, compacts have been used to do things like resolve boundary disputes, manage shared natural resources, and administer regulations that govern multiple states, like occupational licensure. Possibly the best example of an administrative compact that specifically concerns licensure is in the photo on the slide. It's a driver's license. Your driver's license is issued by your home state, but it authorizes you to drive in every other state. And that's because there's a driver's license compact. It's not a federal law. Driver's licensing is a state issue, so states, rather than surrender their authority over that issue, cooperatively developed a compact by which every other state would recognize your state's license. And that's a pretty good model for what we're going to talk about today with the Aesthetics Licensure Compact. Fortunately, licensing compacts aren't just limited to driving. Since 2016, NCIC has been actively working with states and licensed professions to develop occupational licensing interstate compacts, which is what the Aesthetics Licensure Compact is. Now, what are some principles of occupational licensing compacts? As you can see, they facilitate multi-state practice. Compacts create a streamlined pathway for licensed professionals to practice in multiple states rather than having to maintain licenses in every state in which they want to practice. It's important to note that this doesn't remove the power of each state to issue single state licenses. It's just an additional pathway where a licensed professional is able to practice in multiple member states without having to go through each member state's licensure process individually, one by one. Occupational licensing compacts also improve public health and safety. Compacts increase the amount of cross-state collaboration and information sharing, which allows regulators to make better public health and safety decisions. Lastly, compacts facilitate multi-state practice while also ensuring states retain authority over practice within their borders. So they preserve a state authority over professional licensing. The Aesthetics Licensure Compact doesn't affect state scope of practice rules. And you can see here at the bottom some of the statistics about the utilization of these compacts. And as you can see, they have been very popular in recent years and are a proven tool. This slide has some additional data to provide context about the popularity and utilization of occupational licensure compacts. As you can see, the Physicians Compact, or IMLC, has 44 enactments. The compacts with lower state enactment totals are not less popular for any reason, other than they are just newer. These compacts take time to gain momentum and get a majority of states on board. For instance, you can see school psychologists, respiratory therapists, APRNs, athletic trainers, and estheticians are at the far right because they are the newest. And we're excited to have compacts for athletic trainers and estheticians available to states for the first time in 2026. This slide outlines CSG's compact development process, and we've honed it over the years. And there's a lot of information on this slide, and I won't go through all of it, but I do want to touch on a few items in phase one. CSG worked with a coalition of state licensing boards to develop and convene what we call the Technical Assistance Group that you can see at the top of the phase one column there. The Technical Assistance Group is an initial stakeholder group that develops a broad framework for the compact, and the Aesthetics Licensure Compact Technical Assistance Group was comprised of about 15 to 20 people who are all stakeholders in the beauty industry. That includes licensure board administrators, educators, licensees, other industry business leaders and employers, attorneys, and just regulatory experts. The next step in the process was developing and convening the document team, and that was mostly a group of attorneys, board administrators, and regulatory experts that put pen to paper on the compact language itself. This team takes the recommendations from the Technical Assistance Group and drafts the model compact legislation. And we've now reached the stage in the development process where the compact model legislation is complete, and we're in the highlighted bullets under phase two of education and enactment. You might be asking, why is this important? And it's because it's important that everyone understand that CSG didn't write this, and it wasn't written by lobbyists or business owners or licensees themselves or professional associations or any special interests in any sort of back room outside of public view. We researched licensure requirements, we convened experts, we provided information about compacts and best practices, and then we left it up to the experts themselves to make a compact that works for the licensees, works for the licensure boards and agencies, and works for the beauty industry overall. And to add to that, as you can see in the final column in phase one, we did stakeholder review, where we released the initial draft of this to the public, let anyone who wanted to provide a comment on it comment, reviewed those comments, and then made changes if we thought they were necessary. After we did that, we did finalize the model legislation, and it is now available to states and can't be changed. But this is where we do education to make sure that states have all of the information they need to make informed decisions about whether or not this compact makes sense for their state. Now that we have a foundation for what compacts are and how they are developed, I'm going to walk us through the compact section by section and explain what some of the language means and how the compact is to work, and highlight specific policies that should be relevant to the group. If you have a copy of the Aesthetics Licensure Compact Model Legislation, it starts with Article 1, the purpose statement. And what we're really focused on when developing Article 1 is the intended impact and benefits of the compact. What are the development groups trying to achieve for the aesthetics profession, and how will it impact the lives and careers of licensees, state licensure board members, regulatory staff, employers, and business owners? It's important to note that states are not required to include Article 1 in their enacting legislation, but we generally prefer it stays in, as it can be helpful to reference why the development groups included a policy in the compact or worded a provision the way they did. When we think about the purpose statement in Article 1 and the impact and benefits of occupational licensure compacts like the Aesthetics Licensure Compact, we generally think of them in three overall sections. So we think of benefits for licensees, benefits for licensure boards and agencies, and the benefits for states overall. The benefits for licensees are that it enhances license mobility. It also expands employment and career opportunities into new markets, and it supports military spouses and families when they're assigned to new duty stations. The benefits for licensure boards and agencies are that it reduces application processing times and administrative burdens. It also assists in identifying license fraud, and it provides access to investigative and license discipline information that they might otherwise not immediately have access to. And finally, it expands cooperation among state licensing authorities, whether that's through work on the commission or through joint investigations for adverse action purposes. Finally, the benefits for states are that it promotes workforce development and strengthens labor markets, and it expands consumer access to services and the most highly qualified and highly sought after service providers. And finally, it preserves state sovereignty for ensuring public safety and maintaining public health by letting states remain in control of their licensure requirements and their practice acts. Now that we've had a chance to explain what the development group set out to do with the Aesthetics Licensure Compact, let's get into the details that actually make it work. And that starts with Article 2, the definitions. There's 26 of them, and I promise we're not going to review all 26. Instead, I'm going to highlight some commonly used terms that will be helpful for you to understand. The first is home state. Home state is the state where an esthetician lives and holds an active unencumbered license. The term in the definition is primary state of residence, but we're not going to get into whether an esthetician is domiciled there or spends 180 or more days in a state. It's just the state where you live and is your primary state of residence. It's probably your driver's license state. Remote state is any other compact member state other than the licensee's home state. A multi-state license, this is the thing that the esthetician is actually applying for. It's the license that makes an esthetician eligible to work in other compact member states, and so we call it a multi-state license. The multi-state authorization to practice. This is just the legal authorization granted to practice in each remote state by virtue of holding a multi-state license. It can be a confusing concept, but as we continue, it will make more sense, especially when we discuss Article 7 concerning adverse actions. But this is the thing that a remote state can take action against by encumbering, suspending, or revoking if something goes wrong. A remote state can take action against the authorization to practice in their state, but not the multi-state license, because the home state issues the multi-state license, and each remote state issues a multi-state authorization to practice by recognizing a multi-state license as valid for practice in their state. Next is the Compact Commission, or just the Commission. This is the governing body that will administer, implement, govern, basically do everything for the compact on an ongoing basis. And basically, it's important to understand, this is not a CSG compact, this is not a DoD compact. This compact belongs to the states that join it. and these states have agreed to join this compact together, and they're the ones that are going to govern it in the long term. They're the ones who make up the Compact Commission. They control it and administer it. And finally, let's take a look at the licensing authority. In many compacts, this definition would just be a reference to the team of people, either a board or an agency, who issue license to estheticians and regulate the practice of aesthetics, and it'd be as simple as that. But this compact requires a bit more clarity to prevent issues with confusion or possible overlapping concerns about scope of practice issues. And it also ensures that this compact is administered by those who license and regulate the cosmetic and beauty industry professions. Now that we've explained what we intend to do in the purpose statement and defined important terms, let's get into the specific requirements. And in compacts, we generally break it down into two sections. One section contains all the requirements that apply to the states who want to join and participate in the compact, and the other section, which we'll get to after this, applies to the licensed estheticians themselves. So Article 3 deals with the state requirements, and this is what a state has to have in place in order to be a member of the compact in the first place. Obviously, a state has to license and regulate aesthetics. All 50 states regulate aesthetics currently, but if a state ever deregulates or goes to something like certification or registration instead of licensure, then they would no longer be eligible to be part of the compact. They don't license. Next, states have to require that licensees satisfy education and or training requirements. However, there's no specific number attached here. It just says a state has to require licensees to complete education or training programs prior to qualifying for a license. Also, a licensee has to pass a competency exam. Again, there's no specific exam mentioned here. We're just saying that they have to prove they have passed a competency exam prior to being issued a license. And further, the state has to have a mechanism in place for investigating and receiving complaints about licensees. Typically, that's just a licensing board or a state regulatory agency. Every state has one of these, so there shouldn't be any states disqualified because of this point. Continuing on with Article 3 here, the prior slide dealt with requirements that states have to have in place to be eligible to join the compact in the first place. Whereas this slide deals with things that states have to continue to do or maintain to continue to be members of the compact in good standing and be able to issue multi-state licenses and participate in the commission, things like that. So states have to maintain one of the following procedures as a part of the licensure application. The first is a criminal history or criminal record question. Most states use something like this in their licensure application, and then based on certain reported criminal convictions, can make licensure decisions or just ask for additional information about something that's reported. An alternative that some states are using is a license discipline history question. Some states do this in addition to the criminal history or criminal record question, but the compact doesn't require that states do both. If states only maintain a license discipline history question as part of the licensure application, that meets the requirement for the Aesthetics Licensure Compact. And finally, states can do a criminal background check. Only a few states do this for licensed estheticians, and it's typically because of a state law requiring it for all licensed professions. However, if states want to do a criminal background check as part of licensure applications, they are free to do so under the compact, and that fulfills this specific requirement. Just to summarize and clarify, this is just saying that a state has to do one of these things. It doesn't have to do two, it just has to do one. It doesn't have to do all three. And based on our research, every state meets this requirement. So we'd like to reiterate that states don't need to pass a companion bill authorizing background checks or add language onto the end for adding a license discipline history question if they don't do that. As long as your state does one of these things, they're eligible to participate in the Aesthetics Licensure Compact. No further action is needed. Next, states need to agree to upload and update information into the data system. So that's just how the data system functions and is really the backbone for compact operations. States upload information into it, there's provisions, and later on there'll be rules about what information and which licensees information has to be submitted and how often it's updated. But we have to specify that states share this information and do it on and update it on a regular basis. It's essential to the compact that each state plays their part in this agreement. In addition to the data system, we specify that states must notify the Commission of any disciplinary actions taken against the licensee. And this is done through the data system, but we separate it out for public health and safety concerns. It's a requirement in all licensure compacts to ensure that member states can work together, especially on things as important as public health and safety. Lastly, states have to comply with the rules of the Commission. So the Commission is going to have the ability to write rules that are binding on the member states. And as a state, they have to comply with those rules. But as I'll briefly discuss later on when we talk about rulemaking, the Commission is very limited in the compact by what rules they can implement. They have to be narrowly tailored just to clarify or detail how the compact is to be administered and implemented or executed. The rules can't, for instance, specify that only one exam qualifies now, since the compact doesn't specify that and goes out of its way to not do that. Or it can't say that every state has to allow this new service that some estheticians in some member states are providing. It can't tell other states to add that to their Practice Act. That's not a rule that they can write. So these rules are mostly about like what constitutes a quorum during a commission meeting or a committee meeting, or the length of the term for the chair of the commission, or whether the data system needs to be updated every Friday or every Monday or every Monday, Wednesday, Friday, or every day. We're not dictating things to states like licensing requirements or scope of practice through rules, so don't be too worried about things like that either. But now we can move on to Article 4, which talks about what licensed estheticians must do to qualify for a multi-state license in their home state. And really, it's very simple. They have to have an active, unencumbered license issued by their home state. They also have to agree to know and abide by all the rules in remote states where they're practicing, and they have to pay any fees required by the home state for a multi-state license. States are allowed to charge a fee for a multi-state license. So really it's that simple because we put the requirements for a license like education requirements and passing an exam on the state side at the beginning of Section 3. The state requires it, and we require licensees to live in and have an active unencumbered license from a member state. We don't need to duplicate those provisions in Section 4 on the practitioner side. And if you live in a compact member state and have an active unencumbered license, pay your issuance and renewal fees, you should be good to go. The one thing I do want to draw some attention to before moving on is the second requirement on the list. It's important that licensees know their scope of practice from their home state does not travel with them. The applicable scope of practice is the scope of practice for the state in which a client and licensee are located at the time service is provided. If there are differences between those practice acts, it's the responsibility of the licensee to know that and to follow it. We'll encourage the Compact Commission to provide resources where there's differences and discrepancies between member states' practice acts so that licensees don't have to go and read through every member state's practice act, but the responsibility still lies with the licensee, and ignorance of differences won't be an excuse. It's just important to know, but now we can move on to Article 5. And so let's move on to Article 5. Which provides for a reissuance process if you change your home state. And this is important for a few reasons. An esthetician can only have one multi-state license at a time. Currently, licensees can have as many licenses in as many states as they want, but this compact has a home state license requirement, and a person can only have one home state at a time. But what about when someone has to change their home state from one compact member state to another? This compact provides an expedited process for that. You transfer your home state from one compact member state to another, and by notifying the initial and soon to be former home state, that state will cancel the multi-state license that they issued. Then once residency in the new home state has been established and can be documented, you go get your driver's license or a bank statement or something like that, the esthetician can go to the licensure board or agency and show that they had an active and unencumbered multi-state license in another compact member state, prove that they've established residency in the new home state, and then the new home state will issue a new multi-state license. And there really shouldn't be any extra requirements around retesting or verifying education or having to go get extra education hours or anything like that. The idea here is that a multi-state licensee was already authorized to work in that new home state as an esthetician and in every other member state under the compact, so there shouldn't be additional requirements. They were already going to be able to work there before they moved there. The Commission can and will make rules to fill up the specifics of this process and what the application looks like, but the idea is that it's a verification of residence and payment of fees to the new home state, and that's it, because your completion of education and passage of an exam was already verified in the prior home state, that member state. Also, to be clear, this is not just if you are practicing temporarily or seasonally in a remote state or practicing across state lines for those estheticians who live near state borders. This is for estheticians who are actually changing their primary state of residence and moving between compact member states. That's who Article 5 is for. And with that, we're moving on to Article 7. We aren't skipping Article 6. Well, we kind of are, but we'll come back to it and explain later. This Article 7 deals with adverse action, and this is where you should start to see defined terms and some of the principles and policies that we've discussed earlier kind of come in and see their place fitting in with the model. The important principle here is that a state can't revoke what it did not issue. So Article 7 spells out that the home state has the authority over the multi-state license, and the remote state has the authority over the multi-state authorization to practice that is established through the multi-state license. And this is all as it relates to license discipline. So let's take a closer look at how that works in a real scenario here in this graphic. A remote state can take an action on the multi-state authorization to practice. So that's just the authorization to practice in a single remote state. And I think it makes more sense with an example or a scenario. So let's say I'm licensed in Kentucky and I also work in Tennessee. And in Tennessee, I'm allowed to provide a service that Kentucky does not allow. But because I was trained at my job in Tennessee to do this service, I come back and offer to perform the service on a client in Kentucky. Unfortunately, that client is harmed while I'm providing the service, and I wasn't supposed to be doing in Kentucky. There's a complaint and an investigation and discipline against my Kentucky issued multi-state license. Because Kentucky encumbered or suspended or revoked my license, I no longer have the active unencumbered license required under Article 4. So that's how practitioners and licensed estheticians qualify for a multi-state license, by having that active unencumbered license in the first place. Therefore, if you lose your home state license because it's encumbered, you lose access to the compact, and all the multi-state authorizations to practice are automatically suspended. Now, let's say the reverse occurred. I provide a service that is within Kentucky's scope of practice, but is not allowed in Tennessee. I make a mistake, and the client sends a complaint to Tennessee's board. Tennessee can't take action against the multi-state license. Tennessee didn't issue the multi-state license. Tennessee agreed to allow me to practice under a multi-state authorization to practice by virtue of recognizing that Kentucky issued a multi-state license. So let's get into how that works in the next slide. So as you can see, this slide shows how states can act should an esthetician violate the Practice Act in a remote state. Under the Kentucky and Tennessee example we've been using, Tennessee would receive a complaint from a client investigate, and should the complaint allegations be found to be true, then Tennessee could take action against the multi-state authorization to practice. However, the process doesn't end there. Article 7 also allows for a joint investigation. Two or more states could participate in a joint investigation, or a home state and a remote state, or a home state and multiple remote states. That typically isn't necessary because most issues only occur in one state unless there's a pattern of behavior or fraud from a truly bad actor, and we hope it doesn't come to that. The most common next step in the process will be a requirement by the home state to review the investigation documents and reports and decide if action needs to be taken against the multi-state license. The home state would review the findings of the investigation to determine if the incident had happened in Kentucky, if Kentucky would have taken actions under their laws and rules as well. If so, they can suspend or encumber the multi-state license, and then that licensee does lose access to the compact because they no longer have the active unencumbered multi-state license. But that isn't required if the alleged behavior was legal in Kentucky or whatever the home state might be. The most common example of these types of differences would be something like cannabis possession. In some states, a conviction like that can impact the status of an occupational license, but in other states it's legal, so there's no issue. Article 7 helps states navigate discrepancies in situations like that. And one final note here, through the data system, all member states can review relevant adverse actions. So if, for instance, in the scenario we used in which a Kentucky licensee violates Tennessee's Practice Act, and Tennessee takes action against the multi-state authorization to practice, North Carolina, their member state in this scenario as well, could also take a look at that licensee and choose to act against that licensee's multi-state authorization to practice in North Carolina as well. They could decide, oh, that person did this in Tennessee, and we don't want there to ever be the chance that they could do that to someone here. We know that they work here. Even if we don't know that they work here, we can go ahead and take preemptive action based on what we've seen from Tennessee. States are authorized to do that. They're authorized to fulfill their mandate to protect the public's health and safety. I would hope that would be pretty rare, and I would imagine the action would have to be like repeated or egregious, but it's in the compact because of that importance of public health and safety. Finally, you may be saying, well, if you screw up in your home state, the punishment is much, much worse than if you screw up in a remote state. All the remote state can do is, take away your multi-state authorization to practice and share the report, and other states can take a look and decide if they want to do anything or not. But if you screw up in your home state, you lose access to the compact entirely. And yes, that's true. The compact is modeled that way. If you screw up in your home state, it is worse. But you should also know the rules and the Practice Act and the requirements and the regulations in your home state better than other remote states. You live there. That's where you got your license. And so there is a higher bar for understanding what you can and can't be doing in your home state. And should you run afoul of that, the adverse action, the discipline is a little bit harsher. You lose access to the compact. Now that we've had a sort of top-line summary of the policies and provisions in the first 7 sections, we find that the graphic on this slide really sort of helps audiences put it all together and see how the compact is intended to work. So you've got a cosmetologist who lives in a compact member state. We'll call it State A here. They want to work in another compact member state, so they go to their state licensing board or agency and they apply for what we call the multi-state license. So the esthetician applies for a multi-state license to their aesthetics board. The home state verifies that they're eligible. They meet all the requirements that we discussed earlier in Article 3 and 4. And if everything is in place, they issue that multi-state license. And now they're able to practice in all of the other compact member states. So they're able to practice in their home state and in any other state that's a member of the compact without any additional action necessary. And so the analogy of the driver's license that we used earlier is actually a really good parallel here, because it's not like you have to stop at a state border and check in with the licensure board or call ahead to let them know you're coming or pay an extra fee or anything like that. It really is seamless in that Once you have your multi-state license, it grants you the ability to practice in all of the compact member states with no additional action necessary. It's a big mobility benefit to licensees. So the compact is a very long document, and once you get past sections, Articles 3, 4, 5, 7, a lot of the back half of the compact is going to be pretty standard boilerplate legal language that we use across all of the licensure compacts that allows them to function. Article 6, and you'll see here, we're just going to summarize it real quick, is just clarifying language to help member states understand their cooperative obligations to other states. It specifies that member states will work together in good faith and share information to ensure public health and safety standards are met, and that they'll work together through the Commission. But it also explains right at the top that this compact has no bearing on a member state's ability to enact and enforce laws as it sees fit. Compacts help states address common issues, but not at the expense of their sovereignty. So states can and should still direct themselves as they see fit. We've already discussed Article 7's provisions on adverse actions, so we can go ahead and skip to Section 8, which covers provisions for active duty military families. This section in the Aesthetics Licensure Compact is going to look very similar to nursing and medicine or counseling, for active duty military members and their spouses. This just says that an active duty spouse can designate a home state and retain that home state designation regardless of whether they actually live there and maintain their residence there throughout their active duty military service. So regardless of where they are relocated in their military service, they don't lose access to the compact. They can always keep that home state. So let's say for the purpose of the compact, I say my home state is Georgia. I could move, DOD could order my family to move 10 times the next 10 years. It doesn't matter. But because Georgia is a compact member state and I specify that Georgia is my home state for the compact, I maintain access to the compact for all the member states. And I don't ever have to update that until I leave active duty service. Article 9 establishes the compact mission that we've been talking about. The member is going to be the commission member is going to be the primary administrative officer of the licensing board or their designee. So basically the executive director, the executive officer, or the equivalent. Or if they say, I've got a lot on my plate through just this job, I would like to designate my deputy or another staff member who's really good. They can take on this compact role and then report back to me. That's fine too. We allow that. Article 10 establishes the data system and lists out some uniform data set that the states will have to upload and maintain and update in the compact data system and share with each other, and also spell out how regularly that has to occur in rules. Article 11 establishes the Compact's Commission's rulemaking authority. Again, I need to reiterate, rulemaking is very narrowly tailored to the implementation, administration, execution of the compact. So it's just meant to fulfill what the compact already says and just spell it out a little more clearly. All right, let's move along to the remaining boilerplate sections. Section 12 addresses oversight, dispute resolution, and enforcement. We are talking about a legal contract here, so there's a dispute resolution process in place. If a state is not holding up their end of the contract, not enforcing it properly, there are provisions for addressing that in Article 12. In Article 13, the effective date, withdrawal, and amendment. A state can withdraw from the compact, and it's done the exact same way as a state joins a compact. They have to pass a piece of legislation essentially repealing the compact. That's how a state withdraws. So you're not stuck forever. If a state wants to get out of a compact that simply isn't working for them, They can do that through legislation the same way they got in, but this has only happened once, and we hope it never happens again. Compacts can be amended, and this section allows for that as well, but we strongly prefer to get it right the first time because compacts can only be amended the same way they are joined, by passing a piece of legislation. This is a bit like insurance. We hope we never have to use it, but we'll be glad we have it if we need it. However, I do want to discuss the effective date provision real quickly. The effective date is when a compact comes into law into 7 member states, as specified here in the Aesthetics Licensure Compact. It has to be passed by the legislature and signed into law by the governor in 7 states before any of this takes effect. Right now, we're just in a waiting period for the 2026 legislative sessions to start, and hopefully we'll get to 7 states very quickly that pass the legislation, and then we'll get the process of setting up the commission started. Section 14 talks about construction and severability. This relates to the contract nature of compacts. We want to ensure everyone understands the compact commission can create rules to ensure the compact works as intended but can't go beyond that. And for severability, if something completely unexpected comes up and a provision of the compact can't be enforced, then the rest of the compact that can be enforced stays in effect through Article 14. And finally, Article 15, the binding effect of the compact and other laws. This provision just makes it explicit that if there is any conflict between the compact and existing state law, that the compact would supersede to the extent of the conflict, because those were older laws and this new compact law is being passed intentionally, and so they're intending to adopt these policies. The only exception to that is that unless the conflict between the state law and the compact is with the actual state constitution, compacts can't supersede or conflict with the U.S. or any member state's constitution. So again, because this is a new optional pathway to practice, this is not in any way impacting the current licensure system. So true conflicts with the compact are exceedingly rare. We don't really see this a whole lot in compact administration. That's all the information we have to share about the Aesthetics Licensure Compact at this time. And we hope you found it interesting, and we hope you're excited about the compact and are interested in considering it or supporting it in your state. If you have general inquiries about the compact, please feel free to email aestheticscompact@csg.org. That's without an A, so it's ESTHETICS compact, COMPACT @csg.org. I'll repeat that again, ESTHETICS compact, COMPACT @csg.org. If you have questions about this presentation or how to get involved in compact advocacy efforts, or if you're a state official interested in introducing the compact legislation, please email me. My email is there on the screen as well. It's kbuckhout@csg.org. That's kbuckhout@csg.org. I'm more than happy to help in any way I can. Additionally, please check out the educational resources and additional information available at aestheticscompact.org. That's aestheticscompact.org. With that, we'll wrap up this presentation. Thanks to everyone for your time and interest in the Aesthetics Licensure Compact. We appreciate it, and we look forward to working together with you soon. Take care.